initially drew you to migration law and what's kept you in the industry for over 20 years?
Julia, I arrived in Australia back in 2000 as an international student. When I completed my law degree, which was in 2003, I had already gained a little bit of exposure into this area. And being a migrant myself, it was like a natural, organic transition into this area of law. And I've just kept practicing in the area and enjoyed every little bit of that journey.
Amazing. Can you share a case with us that seemed impossible but ended in success?
So many, too many to mention. With complex cases, it's always a challenge at the start, but I really believe that with a lot of focus and time, there's always ways of looking at a complex matter and finding solutions. So too many to mention is going to be my answer to that question.
Perfect. How would you say migration laws have evolved over the last 2 decades?
I see it as a case of supply and demand. Migration law always follows policy, and policy always looks at what is the current need. So where there have been times of acute labour shortage in certain critical areas, migration policy, migration regulations come in to address those gaps. So over the last 20 years, with the economy changing, the community needs changing with COVID and all these other dynamics, I have seen how migration law has really come in to address those gaps.
What's your core philosophy in your practice?
Being true to myself is my core philosophy. I've got skills, I've got qualifications, but most importantly, I believe that as a person, I bring in a certain set of values to my practice. And I think over the years, this is what has held me in good stead and has been able to deliver results for my clients.
What are some challenges that migrants will fall into early in the process?
I think a lot of migrants have too many options these days. They go to different sources to get advice and often gets confused in the process because we're talking about hundreds of different visa types, various pathways that involve different cost structures, different timelines, different requirements. So often it can get very confusing and daunting, and sometimes you can lose momentum in that complex in that sort of complexity.
Yeah. How do you help clients navigate changes in immigration policy?
One of the biggest challenges that I face in my practice on a day-to-day basis, because immigration law is perhaps one of the most dynamic areas of Australian law, and it's really important that I keep abreast of those changes and make sure that my clients' interests are always in the forefront and always they are properly advised when it comes to those changes.
Amazing. Could a rejected case really be salvaged, and if so, how?
Well, in Australia, we've got very strong checks and balances in place. And what that means is administrative decisions, and immigration decisions are administrative decisions, are reviewable. And that means there are processes that we can look at, like the Administrative Review Tribunal that does merits review. And we also have other mechanisms in the area of judicial review, where if there has been an error of law, a jurisdictional error, where we can go to the higher courts to get justice.
Okay. What is your process when someone comes to you after a refusal?
Well, there are a couple of initial steps that I take when I get a new case for a review application. Firstly, of course, I look at the decision record, whether it be a refusal or a cancellation. I get into the decision to see what we can make out of that decision. But that's only a very small percentage of the work. We then look at the overall application that was lodged. I then go to the client to see what information may have not been presented to the department that could have otherwise resulted in a different outcome. So there are a few different steps we take, but most importantly, it is engaging with the client and trying to find a solution to that problem.
What's your experience like at the ART?
My experience at the Administrative Review Tribunal has been great. Over the last 20 years, I've handled so many cases before the tribunal. The fact that there are a couple of reasons why I say that. Firstly, it's a merits review application, which means you can actually present new evidence, whereas in some judicial review matters, like we can't present new evidence, but at the tribunal, we have the opportunity to bring in as much new information as we can. Also, the process by which evidence is given at the tribunal, you're not bound by rules of evidence. So it's a very engaging process, and as a result, we can really engage with the tribunal member and present our case thoroughly, which means the chance to get a fair outcome is actually really, really high. So my experience at the tribunal has always been great.
Amazing. What are the essential components of a strong migration case?
Well, it depends on what the case is. We know that with migration, there are so many different feeders or pathways, whether it be family migration, skilled migration, humanitarian visas, so on and so forth. So there is a different structure for each of those different categories, I would say, but absolutely, there has to be structure in the way we get the information, the way we prepare the application, and the way we present it to the department. So structure is key.
How important is documentation, and how often would you say it gets overlooked?
Documentation is a really important part in presenting a visa application to the department, or even doing a tribunal appeal for that matter. Now, the department's applications, it's not 100% document-based, but I would say that a good 80 to 85% of their focus is going to be on the documents that we present. Now, it's important that we follow regulations, we meet the criteria for that particular visa type, and in doing that, we present the information in an organized, easy to understand structure and manner. So, how we prepare and present documentation, I think, plays a huge role in the success of an application.
Can you share some of your own examples of how small details have made big changes or differences?
Nope. I couldn't possibly. Attention to
So
detail.
many?
No, attention to detail in every little thing is the answer.
How important are skills assessments?
Skills assessments are absolutely important. There are certain visa categories where skills assessment is mandatory. For example, subclass 189, 190, 491, even 186 direct entry. Now these subclasses require a skills assessment. So getting that skills assessment right at the very outset of an application is really important to ensure the success of the application down the track. And I have often seen clients where they have got that process, they haven't got that process right, and they have not been successful in the skills assessment and received a negative outcome. And we've managed to get that overturned and have that resolved. However, that initial few months of getting that sorted can be such a stressful time for clients. So by getting that process right, I think you can avoid that unnecessary stress and pressure.
Amazing.